Well, thank you, Charles, in the Enugu Center. Welcome to Abuja. This morning, we are going to interrogate developments in Osun local government elections. Local government elections in this country have been quite contentious, if you ask me, because politicians have told us that controlling the local government areas is almost the same thing as being sure of being elected next time, because the voters, the population, is in the local governments, and to take control of those local governments means you are in control of the voting population. Now, but I've always raised the question, is it just controlling the local governments? How should a politician be elected or re-elected? Should it not be when he shows that he can perform, whether he's in control of the local government or he's not? And the answer I've always gotten is, you need a structure. And I've always told my colleagues, that is a euphemism for you need something with which you can manipulate the election. Whether they are doing well or not doing well, if those have installed are in charge, they manipulate the election and you win. When are we going to get out of that? And politicians begin to perform, and their scorecard will determine whether they are elected or re-elected. But this is not the issue for this morning. Let me take you through why we are discussing this issue this morning and what we are discussing. On October the 15th, 2022, if you remember, Osun State held local government elections across all the local governments, and that was under the regime of Boyega Oyetola, who was a governor of Osun State under the APC, or from the APC. Now, PDP and all the other political parties in the state boycotted that election. And what was their grounds? That the election did not respect the provisions of the Electoral Act 2022. But the local government election still went ahead in Osun State, and APC won all the council elections. On November the 25th, 2022, a federal high court in Osun State, in Onosogbo, nullified that election on the grounds that it ran foul of section 29 and 32 of that Electoral Act. Now, I want to give all the information here that it was the PDP that took that case to court after APC was declared the winner of all the council elections. Now, the court, that is the Federal High Court in Onosogbo, ruled that that election was not properly conducted because it ran foul of two provisions of the Electoral Act. And that, of course, led to the sack of all the council chairmen and their councillors across Osun State. That was still under the governorship of Oyetola of APC. APC was joined in that case at the Federal High Court, which it lost, but APC now went on appeal to ask the appeal court to look into the merit of that judgment by the Federal High Court. Now, the case was decided before Ademola Adeleke of PDP was sworn in, or rather the case was not decided, that is, the case was still in the appeal court when Adeleke of PDP was sworn in as governor. In other words, when he was sworn in as governor on 29th of May 2023, there were no local governments. But important information here, the case was before the appellate court. there was a judicial intervention to determine the rightness or wrongness of that election. Now, on February 10, 2025, from May 2023 up to February, there was a lacuna. There were no local governments. On February 10, 2025, the Court of Appeal ruled that the processes of the suit that was filed by PDP at the Federal High Court in Osogbo did not follow the appropriate procedure, that they were incompetent. And therefore, that meant that the case could not stand. But please let me say something here. The appeal court never made any definitive pronouncement on the reinstatement of the sacked local government councils. It only said, technically, this process was wrong. Full stop. Now, two issues arose. Adeleke said, and his team said, since the court did not make any definitive pronouncement, it means that the situation remains as it is. There is vacancy. But on February 20th, 2025, this month, the Minister of Justice and Attorney General of the Federation issued a very strong statement. Please, if my producer could kindly roll that statement so that we can follow, and then you see the points raised by the Honorable Minister S.A.N. Fagbemi. Now, let us see what the minister said. I want to read it out so that all of us will understand. The Honorable Attorney General of the Federation and Minister of Justice, Lateef Fagbemi San, delivering his remarks at the meeting of the General Council of Bar Wednesday, November the 29th, 2025, in Abuja, said, "My attention has been drawn to the publication of Osun State Governor Ademola Adeleke concerning the judgment of the Court of Appeal, Akure Division, delivered on the 10th day of February 2025, which nullified and set aside the judgment of the Federal High Court, Osogbo, delivered on the 25th of November 2022. It was therefore, and please mark the minister's word, he said nullified. It has become necessary to issue this public notice to remove doubts, fears, and uncertainties created by misrepresentations and disinformation concerning legal effect of the judgment of the Court of Appeal. Putting matters in proper perspective and context, the event that led to the two judgments was that during the currency of the term of former Governor Oyetola, election was held into all the local governments of Osun State and winners were sworn in. However, a few days before the swearing in of Governor Adeleke, the Federal High Court Osogbo delivered the judgment referred to above, in which it nullified the election of the local government elected officials and removed them from office. As soon as Adeleke assumed office a few days after the judgment, he issued executive order for the physical removal of the elected officials and replaced them with caretaker appointees. Meanwhile, the APC, that was a party in the Federal High Court referred to above, appealed against the judgment, and the Court of Appeal eventually, on 10th day of February 2025, delivered its judgment in the appeal filed by APC. Let me see. The Court of Appeal not only allowed the appeal, it also held affirmatively that the suit that resulted in the judgment of the Federal High Court referred to above was incompetent and consequently made an order striking it out. Accordingly, the judgment of the Court of Appeal held by implication, effectively restored the elected local government officials removed by the Federal High Court back to their offices. Well, the Fagbemi statement goes on and on and on. Last Saturday, elections into the local governments were held against the position of the Minister of Justice and Attorney General. His informed and learned interpretation of the Court of Appeal judgment. He said there was no vacancy and therefore there was nothing to fill. But after the election of last Saturday, against the pronouncement of the Minister of Justice, winners emerged, and in this case, all of them PDP councils. And on Sunday, Governor Adeleke effectively swore them in. Issues. Is there any impunity going on here? Is there any effort to undermine the court judgments? Are we trying to create a constitutional crisis? And toward the end of the minister's statement, he warned of their consequences. And he went ahead to say that this was a constitutional infraction. Don't forget, the federal government has said, and the Supreme Court has ruled, that allocations from the federation account cannot go to unelected local councils. Those sworn in on Sunday, were they elected according to law? Those sacked, were they elected or were they reinstated? Just as I said earlier, the minister said by implication, but the appeal court never made any express pronouncement saying you have been reinstated. Well, I'm speaking just from the documents available to me. Now this morning, what are the issues on the Osun local government elections? And I have in the studio my friend James Ubeda. James Ubeda is a legal practitioner, a lawyer. He's been following developments on this matter and is here to hold a conversation with us. James, yeah, welcome to the program.
Thank you very much.
That's a very lengthy introduction, is it?
Yeah, it is. And thank you for having me here today. It's a pleasure to be here with you.
Great.
Today. Yeah.
Now, James, where do we start from? Let us start from the appeal court. While the case was on appeal, Adeleke was sworn in as governor, and he declared that there was vacancy, relying on the judgment of the High Court.
Very good.
Was that decent behavior on a matter before the judiciary?
Oh, thank you very much again. To answer swiftly, that was not decent. But if you recall, what the Attorney General of the Federation said was, he came up with a steering committee or an ad hoc committee to supervise perhaps pending the outcome of the appeal. But alas, the judgment came up on the 10th of February, and it was so clear. If I will pull back to that same statement of the Attorney General,
yes,
I know you emphasize on by implication,
yes,
but truly, the Court of Appeal is an appellate court, and it does not maybe take witness statement all over again. What it does is it look at whatever has been filed. That's why they say we transmit record of proceedings. They look at the record of proceedings and see and look at it if some anomalies were there at the first instance court, that's the lower court, And in the wisdom of the Court of Appeal, the Court of Appeal came up with the fact that this matter is even not competent, meaning ab initio there was nothing. So truly, by implication, what are we saying? By implication, there was no matter at all. So meaning status quo will go back, and that status quo, what are we talking about? We're talking about the APC local government chairman, as it were, are still those people in charge. Because which court nullified them? Was it not the Federal High Court? And the same Federal Court, the Court of Appeal is declaring now, say, though the people are mentioning that it was technical or procedural,
Yeah, I was going to come to that.
But the Court of Appeal had looked at it holistically. Why go into the substance of what has been brought on appeal? We are saying this is looking at it in its whole totality. It is a nullity.
Can we look at it? I'm coming from point of ignorance, please.
Okay, sir.
Can we look at it in its totality, as you said? The Court of Appeal said you filed a case at the Federal High Court. The process you followed in filing that case was wrong. It is not that the issue, the substantive issue you raised in that matter had no basis, but that even if they had substance, you ought to have filed it in a better process. Does that nullify the judgment, the observations, the core content of that suit?
Clearly it does. What the Court of Appeal simply said was, if the process of even taking a particular matter to court, that's why they say if you must go to equity, you must do equity. If you come with clean hands. If filing even at the federal, well, we'll come back to even if Federal High Court is even a proper court to even file this matter. But Court of Appeal said even the process of you even putting your originating processes at the Federal High Court was incompetent, was not normal. Then whatever gamut of argument you put there that will crumble. Just like they say, you cannot put something on nothing, and you will expect it to stand. It cannot stand. If the process of getting something was ab initio not proper, then whatever you get on top of it is totally wrong. It will crumble. So that's what the Court of Appeal is saying. Your initiating process, what we should call the originating process at the Federal High Court, was not competent, meaning it's nullified. Once it's nullified, whatever story you said after does not hold water. And that is what the AGF is even tying his argument on, that if the Court of Appeal, which is the highest court in this scenario now, has said, PDP, this matter you took, your starting point, the process of even initiating, because in law, the process is very fundamental. You might call it procedural, but the truth is, if you don't open or appeal properly, nobody will listen to you thereafter. Whatever argument so if they've said that, I don't see there being any vacuum again. The only thing that we will now bother ourselves is who was in power before this particular Federal High Court judgment came, which is the local government chairman of APC. So automatically it reverts back to them, because if not for that particular judgment, they will still be there. Forget about the executive order of the governor thereafter. So they will still be there. So I tag with the Attorney General of Federation. By implication, once this one crumbles, then it reverts back to the APC chair.
Let me just help myself. I'm not a lawyer.
Yes, sir.
Court of Appeal has raised a process matter. Can that defect be corrected? In other words, can PDP now, respecting the pronouncement of the appeal court or Court of Appeal, now refile that issue at the appropriate court using the appropriate process to seek to obtain justice? Is it?
Very, very correct, sir. They can. And ordinarily, that should be if they have a proper legal guidance. If not because there's political activism somewhere, somebody's rushing to attain or to achieve something. Normally, you're supposed to go back, retrace your steps, and file again. See, the justice might linger, but if you do it appropriately, someday it will get to your turn and it will favor you. So ideally, what they would have done is they can go back and file the appropriate process in the appropriate court, and they will move on from there.
No, that brings me to a matter you are about to raise, which is also part of what
okay.
I want to bring up. The PDP went to the Federal High Court. Local government elections are state bound. Was it appropriate to have approached the Federal High Court instead of the State High Court?
The answer is it was not appropriate, meaning it's inappropriate. Even the NBA chairman and NBA president, Afam Osigwe, yesterday, some days ago, also mentioned it. Ideally, the Federal High Court, the province of this, the jurisdiction was clearly it's clearly stated in the Constitution, Section 251 has matters that you can delve into, you can attend to. While this particular matter that has to do with local government election falls within that profile of 272 of the Nigerian Constitution, where state agencies, the jurisdiction is for the High Court to hear matters with regard to state agencies like the SEC, the OSEC, the Osun State Invaded Electoral Commission, then local governments. So not for the Federal High Court. Even we have decided cases too in this area. Even in 2015, there's this popular case of INEC versus Ogbadibo local government, where the Supreme Court emphasized that Federal High Court does not have jurisdiction when it comes to local government election. So what PDP did then, perhaps I'll call it forum shopping, perhaps I don't know what they saw to have gone to. They should have been properly guided by their legal counsel that in doing such, we're talking about a state government election. Even if it's a federal government election, we're talking about a state government election, and this time, which, as I said, 272 says it is within the province of the High Court to hear matters relating to local government elections. So even that particular process is also wrong. And based on what even the NBA president said, well, why did the Federal Court not even tell them this matter so much, meaning by itself, Federal Court can say we don't have this decision, shouldn't come here. For them to have even attained, for them to have entertained that matter, to me it's baffling, because ideally the judge itself can say no, this matter should not come before us, then you throw it out. But for them to even give judgment, even judgment even says even the local government chairman should even pay back salaries that have been earned within that period. All that, it was unnecessary, because that is not the proper court to have even gone to.
I do not want to push you into making comment on the competence activities of your brother lawyers. Does this kind of acceptance of what you know is not yours to intervene in, is it a matter of incompetence or is it a matter of compromise?
I'll say let me say it's a mixture of both. And when it comes to political matters, especially in this our country, some persons threw away the professional ethics, because I can speak for myself. Such matter will come before me. Definitely, myself and my colleagues in the office, what we'll look at, we'll table it and look at how do we marshal, where are we starting from, what is the originating processes, which court is the proper court, and all that. There are a lot of counsel around this, but for somebody to rush in trying to achieve a goal and all that, to me it's even elementary for a local government election to take it to a federal high court, a federal mission. Even the word federal alone, I'd even say no, please. So I won't say it's incompetence, but I know it's pure greed on the part of some of our professional colleagues. Perhaps they have something they want to gain, and they feel, if you recall, at that point, I think the former governor was still in charge, Oyetola. Perhaps they feel if they had gone through High Court, they feel since Oyetola is still the governor, they might look at the state High Court might want to, because of the political connotation. So it's okay, let's just try it to the federal court, which is even a wrong process. And that's why, as professionals, as lawyers, we should follow the due process. If it doesn't work, there's always a higher court, an appellate court, to ventilate whatever you feel it was not properly done at the court of first instance. So I would say counsel that filed those things, they did that perhaps based on some personal gains they want to gain. That's what I feel.
Well, this morning we're looking at issues in the Osun local government elections. My guest remains James Ubade. I'm here with him in the studio. We take a short break now and we'll return, because there are too many matters arising from the very election that we are going to have to interrogate. Please stay with us. we're still interrogating issues in the Osun local government elections. And my guest, James Ubade, is still with me here in the studio. Now, James, this statement was issued by the Minister of Justice and Attorney General of the Federation, Fagbemi. The governor seemed to have ignored it and gone ahead with the election, and thereafter went ahead and swore them in. What will be the effect of the appeal court judgment on the tenure of these gentlemen and ladies who were sworn in on Sunday?
Okay, as I said earlier on, you cannot put something on nothing and expect it to stand. That is the popular case of USC versus Mark Ford. The Attorney General has said it clearly, and there are a lot of implications thereafter. I even saw it over the not social media, one of the news, where even they said the governor Adeleke mentioned that the Attorney General is not the court, so he cannot tell them not to go on with the election. It's so unfortunate because the Attorney General is the #1 law officer of the Federation. So whatever, in my own interpretation of what has transpired, based on the explanation we had earlier on, those that have been elected and sworn in are not sitting down properly. They are not on proper footing, because whatever election that has been conducted, it's a violation of what the judgment of the Court of Appeal, because the Court of Appeal has said a particular Federal High Court judgment which you are sitting on was saying the process of initiating that particular was wrong ab initio. That means, to put it simple, the status quo before that filing remain, and which is the APC local government chairmen who are ordinary, their tenure will be expiring in October 2025. So I think they're just sitting down there watching, and thank God even the governor has said they should not go close to the local government, maybe because of perhaps the breach of peace and all that. But the truth is, if wise counsel had prevailed, left for me, that election should have held
at all.
At all.
James, that's an issue I'm going to bring up. But before I do that, let me draw our attention to the judgment by the Supreme Court in respect of financial autonomy of local governments, their independence. Elected governors cannot be sacked and replaced with whatever contraption, caretaker committee, zone administrator, whatever have you. But just in the same statement that Fagbemi released, he drew attention to the fact that state governments are still going around finding a way of manipulating and displacing elected local governments. And he said that it will have its consequences. Just a minute. And now we are conversing. Supreme Court ruling, the highest court in the land, and some state governors feel comfortable to display this kind of impunity and disregard for law and order. Now here we are conversing on a court order, and is being undermined by state action. Please look at the implications of this level of lawlessness, as it were, by our elected political administrators. What does it hold for the stability, for the peace and order of our society? In our system, we have already been killed.
Yeah, we sympathize with those lives that have been lost, and we commiserate with the families that have lost one or two of their breadwinners. It's so unfortunate, and this is where politics is taking us to. You've mentioned, yes, July last year, the Supreme Court gave this ruling, how the autonomy, the local government autonomy, stating that emphatically that the local government are the third tier of government and should be seen properly so called, and referring us to section 7 of the Nigerian Constitution, where it gives that power to the local government, the autonomy and all that. And as you said, no governors should come under the guise of creating one caretaker committee and all that. You don't have the power. The local government should be saddled with their responsibility to take their activities as appropriate. But this has been done, as I said, because of political gains, and governors truly go around somehow to see a way of circumventing this. And this is a clear picture of violating what the Supreme Court has pronounced. And the AGF has said it succinctly that there are dire consequences. And part of what they can do, there are a lot of allocation coming and all that, which they can stop, and also even the legal issues. I know cases, it is not the end yet. There are a lot of cases still coming out of this, because some other persons are going to court to still test. This particular issue we're talking about will go even up until the Supreme Court, where at least a finality will also be put to such kind of rascality. And it's so unfortunate it's not putting our country in the proper perspective. And more so, it is not leading to, because you were asking where is it taking us. It's not taking us anywhere. Instead, some persons will be feeding out of this illegality, and some persons will obviously die, and which we have started seeing if proper care is not taken. So it's better, before you take steps like this, get proper guidance, get proper, except you're doing it for a selfish reason, which is what is playing out here.
James, let us come to a critical matter. It's a debate that has lingered and lingered in this country. When Fagbemi issued his statement, Adeleke taunted it. And one of the reasons he taunted it is because he perceived Fagbemi as a partisan. He is the Minister of Justice and Attorney General. Who is the Minister of Justice? He is a partisan legal advisor to an APC government. That's what he is. He was not promoted because of his career to the judiciary to occupy that position. He was appointed as an APC candidate minister. That's what he is, in fact. And again, he is the Attorney General. In other words, he is a partisan with prosecutory powers. Over the years, there have been arguments that why does Nigeria not separate the office of the Attorney General and that of Minister of Justice? The Minister of Justice sees himself purely as a partisan legal officer, playing partisan role in the interest of his partisan principle, defending the interest of the party. And it is clear, while the Attorney General is a career judicial officer minded to prosecute A, B, C to Z, not as a partisan. This has popped up now. What is your take on this argument?
Thank you very much. Yes, as you said, this argument even has been there, even some of us through the days of our secondary school at university, with part of even the assignments we even had, even in our university and even in our master's program. If you notice, it has been there since our time of independence. It has been fused. The fusion of the Attorney General and the Commission, the Minister of Justice, as also in the state wise to for state to commissioner. And yes, there have been the argument for and against, and a lot has tilted towards the one for separating these positions because of what our politicians are turned these positions into. Because in other climes that we've copied from and all that, like, they have it separate. Like Canada, I think Canada, United Kingdom, we have an Attorney General different from
Minister of Justice.
Minister of Justice. And why is this so? Because so there won't be that bias. There won't be that, even if there's no bias, people will quickly say it. No, you can't. The same government that brought you into power, definitely you will. These are your paymasters. You will somehow fall to their biddings. So my own take here, if you look at those that have argued that no, we should continue, they're saying no, it helps. It's less spending. You don't have two different portfolio. There's one place you can, so that you know the Attorney General can see and do the same thing at the same time instead of having them in two different offices. But no, I know Section 150 of the Nigerian Constitution gives that power of fusion Attorney General and Minister of Justice. And but still, when you now look at it in the prosecutorial part of it, if you want to prosecute as an Attorney General and a Minister of Justice, definitely you want to lean, there will be conflict of interest in terms of your political affiliates. And this is what we've been seeing in our Nigerian system. And that's why Nigerians are saying, no, the Attorney General should be different. Because even in our Constitution, Section 174, give the knowledge prosecutorial power to the Attorney General, that you can take over, you can stop, you can discontinue. And we've seen that in some high-profile corruption cases in the past, where you see an Attorney General, before you know, the prosecutor from the Minister of Justice just come and they are stopping this case on the request of the Attorney General. And people have seen this bias over time, and because of the political lineage, being an Attorney General and a Minister of Justice. So I am of the view that this position should be splitted. That fusion should be splitted. We should have an Attorney General that will be unbiased, that, you know, once you say anything, if you were to be just an Attorney General, that your ascension into the office is clearly stated, is not tainted by any political leaning, Governor of Osun State wouldn't have said he's not the court. He does not, because he's an Attorney General, a law officer of the state. But because of that political affiliation, that you are Attorney General, and I'm a Commissioner, a Minister of Justice. So that means whatever you're doing, you are saying what APC is saying you should say. So my own take to this is, the Minister of Justice should be separated from the Attorney General. That is where our Attorney General of the Federation will have that proper respect, where everybody will say, whatever you say, you say it. But now, whenever you say it, we'll look at the party you're coming from, because you are saying it because you are APC. You are saying it, perhaps the president and the cabinet that say you should say this. They will not look at the legality of what you're talking about. So that argument, that lean argument, is no, because of resources, it's better it's fused. No, it is not. It's not our resources. Let us do the right thing, because it has been abused over time, and so that there will be that sanctity and that respect for that office of the Attorney General of the Federation. Because Minister of Justice, what does he do? He basically, the aspect of Minister of Justice, your legal advice, policies, policies of judicial policies and all that are things that you see that will align with the policy of the government in place. But for Attorney General, you follow the law as it is. But now, when you now stay in the fusion of those two portfolios, and you are saying some things, an affected party who is on the other side and opposition would never see it in the right path, because it will be, because it has already been tainted by that political power, the political party in power. So I am of the view that over time this argument should be tenable, and our legislators, the National Assembly, someday should look at it and let somebody bring it as a bill and call for public hearing at the appropriate time, and let people come and canvass the argument on this. Because truly, once we do this, once we get it right at that point, a lot of operation, a lot of things will be taken care of. And whenever an Attorney General, be it of the Federation of a state, pronounces, you know, no, this is coming from an Attorney General and not a politician.
I want to draw attention to statements that have been credited to a number of politicians in Nigeria. Join APC and all your sins will be forgiven. It's on record. I can play it back so nobody can say I did not say it. The anti-graft agencies sometimes are said to be handcuffed by political interests. They want to pursue a particular offender, but the offender takes refuge in the political party he belongs to, especially those in power. Is it not evident, therefore, that if we separate the Minister of Justice, the portfolio of Minister of Justice, from that of Attorney General, some agencies responsible for keeping our country clean can then become unfettered, and the society can profit from their unbiased, uninfluenced activities?
Very correct, sir. Very correct. It's still trickled down from my earlier argument that once you have an Attorney General that is untainted, an Attorney General that has the process of bringing such an Attorney General into power is clearly defined by the constitution and not by any political party that because you are affiliated to this party, I'm giving you this position. No, you earn it by your year. I know the constitution says minimum of 10 years at the bar, but that you earn it based on the stipulated provision of the constitution. Once we have that, our security agencies will follow suit, because you'll be surprised, even some of them, even some of the heads of these agencies, at times their hands are tied. So some of them are even out of frustration. At times they say, you heard somebody say, if this does not happen, I will resign and all that. If you assess that particular statement, look at the psychological part that statement is coming from, you know there is a fatigue and there is a stress coming from somewhere. And because you know there's a connotation of some powers now, because you know for every high profile case, corruption cases, just like Buhari said, corruption fights corruption fights back. As you're trying to see how to gather your evidence against those persons we are talking about, they are going to their political godfathers, and you see different calls will start coming. Those heads of those agencies, they get several calls telling them, don't do this, don't do that. So but we have a proper streamlined office of the Attorney General.
Let us even go ahead and please, as you're making your contribution.
Yes, sir.
When the Minister of Justice offends his master, who appointed him, the president can sack him, and therefore his job ends. The Attorney General, as a career legal officer, is not subject to such threat. In other words, the Attorney General has stability, and he outlasts governments, regimes. So he's Attorney General by virtue of the number of years he stayed and is promoted to that position. Government comes, government goes, he remains there.
Yes.
And you cannot threaten him that you are going to sack him for doing his job. Today, if Fagbemi steps the wrong way, if he dances to the point that Tinubu is not pleased, Tinubu is at liberty to sack him because he is Tinubu's appointee. Whether he's Attorney General and Minister of Justice, was appointed, he did not grow into that career.
You're very correct, sir. He can even be sacked from the point where he's even giving a speech against the president. While you are giving a speech, you can just get a text from there. Don't go back to the office. In short, they will stop you from. So that's why once you have a clean-cut Attorney General of the Federation with proper amendment of our constitution stating this is how you are sent to that particular position, and this is how you will be removed when you see everybody will fall in line. Even if there are loopholes, there may be loopholes because there's no perfect law anywhere. But the truth is, we will start getting it right at that point. But as you said, that with this now, if you say anything just because you feel okay, at times some people will say, I know he's a senior advocate, or the particular Attorney General is a senior advocate, the president cannot push him. It's a lie. The president employed you. If you are not dancing to the tune of his policies and you are saying you know the law even more than them, they will. At that place you are giving that press statement or that press, whatever you are saying against the government, there and then that your aides will even leave you there. They will only leave that particular place to you, whatever, perhaps your private office from there, because once the decision is, they can fire you at any time without recourse to you. So it's better, and the argument for the Attorney General being separate is a plausible one, and it's something that we should look at, and the National Assembly should look at this, and we pray someday a bill should come around. I know that there have been bills in that aspect, perhaps they shut it down, but I just pray somebody else bring it up again and let it go at least to the first region, the second region, and let a public hearing be held. And you see, people will come out for it, because it will also even help the legal profession too. It will give us even that respect too. But now, if an Attorney General speaks, they are not even looking at the Attorney General part, they are looking at the Minister of Justice, because they are looking at, although Fagbemi is saying, I never knew him as a politician. No. But the truth is, once you are now being appointee of a politician,
he was a friend of the politician who appointed him, not his enemy.
The same word used by him, by implication. You are a politician now.
He's a partisan.
Yeah, it's partisan, because you have, there's a manifesto to follow. There's a particular scorecard to be achieved through the same government. So if you do anything contrary to the wish and caprices of the government, definitely you'll be thrown out.
Well, what brought us to this conversation? Let us just recap quickly, just in case you are joining us midway. On October the 15th, 2022, Osun State, under the governorship of Boyega Oyetola, conducted local government elections. PDP and other political parties boycotted that election on the ground that the election did not follow the prescriptions of the 2022 Electoral Act. APC won all the council elections in that election. They cleared everything, and PDP went to a federal high court to challenge that election. On November the 25th, 2022, the Federal High Court in Osogbo nullified that election on the ground that it ran foul of Section 29 and 32 of the Electoral Act 2022. Now, the court ruling led to the sack of all those local councils in Osun State, and this was still under the governorship of Boyega Oyetola. The APC, which was a party, it was joined by PDP to that case at the Federal High Court that sacked the local government councils, went on appeal. The case, if you remember, was not decided before Governor Ademola Adeleke was sworn in on the 29th of May 2023 as Osun State Governor. On February 10, 2025, almost 8 to 9 months into Adeleke's office or tenure, the appeal court ruled that the processes of the suit filed by PDP at the Federal High Court seeking to sack all those people was faulty, and therefore struck out the case. Now, as I said here, on technical ground, my lawyer guest, we should come back to that to maybe correct me and teach me better. The Court of Appeal did not make any definitive or express pronouncement on reinstating the sacked council chairman. And on February 2025, Minister of Justice and Attorney General issued a very lengthy statement, which we read, and he said, by implication of the ruling of the appeal court, that status quo before going to the appeal court or at the beginning remains, which means those who are sacked have been duly elected. But Governor Adeleke now says that is hogwash. In other words, Attorney General is saying his own, and went ahead on Sunday to swear in all the council elected council chairmen and their councillors, and says there's no vacancy. In the course of all this, people have lost their lives. In the course of all this, the governor now says, please don't go very close to the council. And so we have a confused situation. That is the conversation we'll be holding this morning. James, this is political rascality versus legal procedure. How does that help our democracy?
In short, it portrays us in a negative light, and it does not help our democracy. Some persons say, okay, we're learning, but you're learning at the expense of people's life. We have a lot of people that have died because of this particular political, what I call it, higi-yaga in Osun State. If the governor had followed the due process, okay, since this is what the Court of Appeal said, let us file a particular. There might be a stay of something somewhere, a stay of execution or proceedings and all that, but it was not done. No, now they were hinging on the fact that it was the appeal matter was on technicalities. No, Court of Appeal this is the second to the highest court of the land, and he has said the process. As a lawyer, you know there's a process. They say if you wash your hand well, you will eat with elders. If you don't want to, they'll tell you go. Even if you are carrying something, that thing you are carrying, they say no. Either you should keep it, or because of that you might not even eat again. So there's a process you must follow to file this, and you have not followed this. So the court of appeal, in its wisdom, has said no, this is incompetent. Meaning there was nothing on ground. If they said something was no longer not there, then you cannot.
There's nothing there.
There's nothing there. So for the governor, if you see the way at which he was even so hasty in even swearing them in, even on a Sunday, because then you know that there's not, something is wrong somewhere.
No, James, Governor Adeleke is a very serious Christian, so he wanted Sunday blessings on the council chairman and the councillor, so he had to put his blessings on them.
So even that, I even saw some other governors, his colleagues from the same party, they were there also to also bless what their own colleague has done. But the truth is, it doesn't help our democracy, and it's not portraying us in a very good light.
James, as they bless this, coming to the end of this program, just have less than 2 minutes or 1 minute to go. Is there anything politically that can be done to correct this nonsense? Pardon my use of the word.
I'm not a politician, so politically I don't know what might be done.
But legally,
if it's political, that means the two political parties are the heads. But legally, as it stands, the governor, to me, in my own view, they are not standing properly. Then the only thing is to annul what they've done on the 22nd of February, and it still doesn't have a power to even put in caretaker and all that. The right people that should be there is the APC, based on the scenario. Not that I'm an APC, I'm not a politician, but based on the scenario, I haven't pulled out that string that they were standing on from the Federal High Court by the Court of Appeal.
They have nothing again.
Nothing again. So
well, James said, "Have nothing to stand on again," and my producer says, "You have nothing to stand on to continue this morning. Your time is out. So get the hell out of the studio." I'm not Trump, who swears all the time, so I'm not to get out of the studio. But I have to thank James Ubade for coming this morning for us to look at the issues in the local government elections in Osun State. There are takeaways. Please, our politicians must do away with rascality and impunity. They don't grow our democracy. Is there a remedy? Yes, there is a remedy, he says, and the remedy is go back to the court, the lower court from where you started, file it within using the right process, and go to the appropriate court. Don't shop for a favorable court that will look at you with kindness. Kindness? No. Don't forget that Lady Justice is blind. Let them go to the court and not undermine the pronouncement of that P court. That creates problem for us. On your behalf, James, thank you very much for coming to the program.
Thank you, sir. The pleasure is mine, sir.
Great. And my name never changes, always Mwaboz Njoko. Can we meet tomorrow in the morning? Good morning.